We're live.
All right.
All right. Attorney Banias, we have some very good news, don't we?
We do. Good decision.
So as some of you may have seen before, when we did our last podcast, we had oral arguments in the Sixth Circuit. Brad was the one who did that. He did an excellent job fighting for our right to party in the EAD space. So the judges were very impressed, and you can go listen to that previous podcast if you want to hear more details about the oral arguments itself. But the good news is now we got a decision, didn't we?
We did. A lovely decision, and actually pretty less than 3 months, which is really fast in the grand scheme of things.
Yeah. Now, so I was on a plane coming back into the country when you emailed me this, and when I saw finally the text message come through from the Sixth Circuit, because I have it set up to come right to my watch, right? And I was like, oh, if he's happy about something with this case, that means this is a win of some sort. And when I got a chance to finally read the whole thing, it was like the language that they used, or that the judges permitted to be used when their clerks were probably writing this, was very surprising to me. I don't know about your law school, but when I was going to Cooley, they taught us, yes, avoid the here and befores and here and thereafter and the before mentioned, that type of archaic, legal linguistics. But they never taught us that you could treat it like a dialogue. There's parts in the decision, and we'll get to ultimately what the decision means, but there's some pretty neat parts where it's like, this statute allows us to do this. Why? Like it's a one-word sentence. Why? And then it answers its own question. So it reads more like you're going through a frequently asked questions section of a website, as opposed to a recommended for publication Sixth Circuit legal decision. But it was great fun. It's great fun. So let's give the audience a little bit background on what the decision actually says. So Brad, how good did we win this one?
Pretty good. And I agree with you, James, that the tone of this decision is definitely a little bit more cheeky or snarky.
Cheeky. That's the word I told my wife. I said this was a very cheeky.
And I think that's an indication that the government, the court felt that the government overreached, and we talked about that in our last time we had a podcast about this, in that they were advancing arguments that no courts have ever really adopted, and I think the court kind of didn't appreciate that. So,
well, no appeals courts. They've won those arguments in the district courts. They won in three of my cases.
It's a very good point. But like we talked about last time, when the government can't admit that a 10-year wait or a 15-year wait would be unreasonable when the judge obviously thinks it is, that's how you get decisions like this, frankly. So a little bit of background on the case, right? These are 4 separate U visa waiting list delay cases.
Slash request for the pre-wait list work authorization that's technically authorized under subsection P6, right?
Yep, that's right.
Which I've never seen one of those arguments win in a circuit court. Has that won before?
No, it is not. Well, it has now. So yes, we sought work authorization under the bona fide determination, and we also sought placement on the wait list. 4 different families, 4 similar stories, all facing a 5-year wait. We filed the cases in the respective trial courts, the lower courts. James and I unceremoniously lost, and so we appealed it. We got to argue all of these in one case up at the Sixth Circuit, which we did in June. And the panel came back, and there's 2 parts of the decision. And I won't go too much into the first part because it's really hyper-technical, but it's for an area called jurisdiction. Essentially, the government said, sure, you may have a problem with us. Sure, you may think that 5 years is too long, but this court's not allowed to hear these types of claims. And they get really hyper-technical, and I won't get too much into the weeds of them. But this is where the government wins these cases a lot, unfortunately, because they go in and they go to a judge who may not have seen these types of cases very often, and they spin good rhetoric, but they're pretty wishy-washy in the law. And but you still see decisions that say, nope, even if we wanted to help these people, we couldn't because Congress won't allow it, right? Congress won't allow it. Well, long story short, the first 27 pages of this opinion deal with those two issues, with that issue over both of the two claims. And they reject the government's arguments every which way they can. And James, you are right. When we were seeking the pre-waiting list work authorization, there's only to my knowledge, 2 or 3 other trial courts in the country that have said they have jurisdiction over it. And so now the Sixth Circuit is saying, yes, USCIS is required to consider applications for work authorization at the outset of the process. Whether they eventually issue those is discretionary, and we didn't disagree with that.
So, and what they said was like, and I think, I don't know if we would have gotten the same wording or the same decision if the BFD process hadn't been already announced by USCIS, but that just sort of underscored it that like, oh yeah, even the agency realizes there's sort of this responsibility to do it. And so they said they have to determine whether it's pending and bona fide. Anything else after that's up to them. And whether to exercise discretion to issue the work authorization. So it's a huge win.
It really is. And now that they have the BFD memo, right, that tells you what their discretion they're going to consider, right? It kind of captures their discretion. And before we go any further, I just want to point something out because this is a little strange. My daughter, I have a 4-year-old daughter. She filled up her sticker chart for being good about going to school. She got a nail polish kit yesterday, and she got me.
Nice.
So if while I'm talking with my hands, you see that my nails are painted beautiful blue and pink, it's not my normal choice. I just love my daughter. And I thought this would peeled off, and it doesn't. So I was drinking the water. I was like, oh gosh. Anyway, back to podcast. This is a break and actually I guess a difference in another circuit court opinion, appeal opinion out of the Fourth Circuit. They said there was no jurisdiction of this claim. The Sixth Circuit said there was. But long story short, and again, I don't want to get too much into the weeds of the jurisdictional stuff for this podcast. But essentially the court said, look, there's no jurisdictional hurdles to these claims. And that in and of itself applies obviously to U visa, U status, U waiting list, and the BFD process, but any other immigration benefits in Michigan, Ohio, Kentucky, Tennessee. Is Tennessee the 6th? I think so. It's pretty clear there's now jurisdiction to consider those, which is good to have.
Yeah, because the section that they ruled under, they said, well, we've got this one, and the heading says decisions in removal proceedings, which I always learned and I always ask the question because I read it in immigration law. I'm like, well, wait a minute. The heading says removal proceedings, but ostensibly there's a subsection in there that says any other decision of the attorney general or whatever in this sort of thing. And so the government's argument has always been that section means anything in immigration, even though the section title says removal proceedings, and the first and the second and the fourth and the fifth and everything else in there is really referring just to removal orders that are issued.
And that's the interesting part about this decision. They kind of go further than a lot of other courts have done. I don't, and even farther than we asked them to be frank.
Well, and to be fair, it's ambiguous, and ambiguities should be skewed or should be interpreted in favor of the plaintiff.
Of jurisdiction,
affected party.
But I will say, technically, and if you are a practitioner thinking about bringing these cases in this circuit, this really helps the practical side of filing these cases because the jurisdictional arguments are now they don't have those available to them. which kind of takes us to the second part of the decision, which I find very valuable and very interesting. And so the second part of the decision relates more to our allegations that a 5-year wait, or actually looking at our actual plaintiffs' waits, I think it was from 15 months to about 40 months was the range, if memory serves.
Up to 60 and a half now is what they would.
Well, I mean, our actual plaintiffs, how long they had been waiting. I think it's
yours were 2016, mine were 2018.
Yes, yep, that's exactly right.
Yeah.
So whether we could say as a matter of law they've waited an unreasonable amount of time,
right?
And this is where the government's motions to dismiss in these cases get really, really tricky, because obviously the government has more facts than us. They know why these things are delayed, but they don't address
be able to find out.
Right, or that information is
trial counsel doesn't know why. They have no idea.
That's very true. But they've been very successful with these motions to dismiss, basically saying, okay, you've waited 32 months. Well, the processing time is 50 months. Yeah. So you're saying 32 months is unreasonable, even though people are waiting 50 and 60 months. And
so their argument is whatever the published waiting time is reasonable, because that's what everybody has to wait. But even in oral arguments, the judges in the Sixth Circuit in our case, they said, well, wait a minute. You're presuming that that's reasonable just because everybody has to wait it. But it could very well be that everybody's waiting for something unreasonably long.
That's right. And so, going to that argument, you have to understand around the country, and as you know, James, that's a very powerful, persuasive argument to judges that, well, if it takes everyone else 50 months, why should we say 32 months or 16 months is unreasonable?
Right.
And our counter is exactly what you just said. And this decision we were talking about, cheeky, right? This is probably my favorite line of the whole decision. But the court just basically said exactly what you just said, James. Well, we're looking at the process. If the whole process is unreasonable, then why should we care what your times say, right? And the way they say that,
it's on page 30 there.
Is it page? That's on page 30. Gotcha. Okay, so I had this highlighted. Oh my god.
The century mark.
Oh, here we go. So they address the processing arguments, and this is what they say. This is why they refuse to kind of look to the processing times as kind of a bellwether or a comparison mark, because they say we find it unhelpful to fixate on the average snail's pace when comparing snails against snails in a snail's race.
It's so good.
It's very entertaining, but they're right, and by the way, that's the kind of language this decision has throughout, which is why I think, the judges kind of got fed up and the government went too far. And that's what they're saying. And again, I say this is great for this decision, great for these particular plaintiffs, but it's even globally in these types of cases, taking away the argument the government has about processing times is huge. And it's really important to delay cases in general. The court goes on further to basically say, well, if we adopted that, you would eviscerate judicial review of any of these delays, because you could just say, well, our average processing time is 72 months or 80 months, right? And then all of a sudden,
now, there's nothing published right now.
Oh, they pulled it down?
They pulled the number down, and what they said is, well, this new BFD process, this bona fide determination process is really going to change things, and we're going to start gathering data. So for now, we're just not going to show any numbers. So if you go there, it's blank. There's not even an estimate.
I did not know that. I guess my thought on all of this is I never trust those numbers anyway.
Because they always grow. They're unreliable.
They're wholly inaccurate. I got a declaration about a different type of benefit, and they have processing times up there, and then they swore to a court that they don't even collect the data necessary to calculate those processing times, yet somehow they appear on the website month after month. So
within a 0.5 month range of each other. So it's like 40 to 40.5 months. So that's pretty specific. And
well, it's pretty absurd. But again, going back to this decision, there's very few courts out there who have gone through the government's what I would call standard or form arguments in these delay cases and just
look deep,
and debunked them. Yeah. Another one that is very valuable, and this goes to another good point, is they claim that this is a really complex process. And
before we get to Mashpee, let me point out this quote here because it's on the delay thing. It says, well, you remember during oral arguments they asked the government attorney what amount of delay would be unreasonable? How long, by just the mere passage of time, could we say that, yeah, okay, for sure that's unreasonable? And the government wouldn't answer. They refused to answer. Oh, we don't want to speculate. Of course, we feel bad about them, but blah, blah, blah. And then you got up and you said, I can tell you that 10 years, that could be reasonable if there's these various factors and they got to investigate and check birth certificates. And then there's a hit on the database and they got to go back. And so you gave them that tool. And so in the decision, the court says, on the contrary, we can easily envisage an extraordinary length of time that would be unreasonable on its face. Waiting a century to hear back about your U visa application, for example, is patently unreasonable. We thus refuse to adopt the government's radical rule in the case before us. And I mean, we're not dealing with 100 years yet, but there's other case types, there's other immigration benefits that are waiting close to 100 years. So it's pretty instructive that they would say, look, there is some amount of passage of time, because they say earlier in the decision, they point out that the government is refusing to say that just the mere, what their argument is that the mere passage of time isn't enough for us to claim that there's unreasonable delay. And the court's response to that is, the defendants claim, although we have been unable to find any authority to support their claim, that it can't be enough, that the mere passage of time can't be enough to make a claim of unreasonable delay. So that's one more door that's clearly open in the Sixth Circuit, where we can say, look, res ipsa loquitur, man, the thing speaks for itself. It's 20, it's 5 years, it's 10 years, it's 15 years. It's just too much in any situation for these things to be waiting in the line. So,
well, and that's right. And kind of thinking about how this decision really does impact the next delay case in the Sixth Circuit, the court at various times points out when they're debunking these arguments that part of debunking them is you haven't proven it, but there's one way to figure out the truth, and that's a thing called discovery.
Yes.
And so one of the other strong arguments the government has, and intuitively it is strong, they say, well, don't grant this motion for the plaintiffs because all it's going to do is jump them to the front of the line. They're just going to go from, spot 5,000 in line to spot number 1, and everyone's going to get pushed back.
Mm-hmm.
And why should these folks benefit over the other folks, right?
And let me share this, that I was flying back from Colombia earlier this week. So I was down in Colombia with our software development team. We're doing some leadership training and planning for the next year. I'm on my way back. We're in the immigration line in Fort Lauderdale, which because of social distancing, I mean, no one in line is social distance, but they keep you can't just go straight into the next room. Somebody jumped the line. And right away, people were speaking out, hey, and they went to the authority. This guy's jumping the line. He was all the way back there. He jumped from this side to this side. He passed 80 people. It's unfair. It's not right. It's unjust. You need to get him out of here. And then there's one Border Patrol officer. Then there's 2 Border Patrol officers. Then there's 2 Border Patrol officers and 2 people who work for Spirit who are trying to figure this out. And I mean, the concept of jumping in line is for a human being, that is a strong set of emotions you're playing with. So when the government says they're just line jumping, it's more than just, they're doing something that's just, going to be inconvenient for others. No, what they're invoking the one thing that people across cultures, across languages and societal norms agree on is that you can't jump in front of a line, at least at an airport. So,
Well, and that's why this argument has had so much traction at kind of the lower courts. I mean, it intuitively it's appealing, and intuitively it doesn't make sense that you would make decisions on applications in any other processing logic, right? Obviously, there's a line. You send your applications in. The ones that were there before you are ahead of it. The ones that come in after you are behind you, and yours is in the middle there.
Yeah.
But the system is so broken, and there's so many exceptions, and there's expedites, and there's prima facie determinations, and there's folks in removal proceedings, that this concept of a line is just eaten by its exceptions. And that's always been our argument. But what the court said here was basically, well, the government claims there's this beautiful, perfect line, but the plaintiffs allege there's not. We need discovery to learn.
Yeah.
And they say that about a couple of other parts about how complicated this is and how long it actually takes. Oh, we need discovery to deal with that. And it's just kind of offhanded comments here and there. But that is an incredibly powerful comment by the appellate court. And let me explain why. If I'm the government defense attorney and I know that if I don't settle this delay case, I'm going to have to answer discovery, which means questions under oath by my client, document requests, potential depositions where someone from the agency has to sit down and answer questions under oath. It changes the calculation of settlement completely. And I will tell you this, the government doesn't like discovery of its documents for good reason, because they typically don't. In delay cases, it's really hard for them to support their position. So just having those comments in there in this decision, I think it's in like 3 places, that no, discovery be necessary, it really changes everything in delay litigation in the Sixth Circuit for plaintiff friendly, in my opinion. That's something they're going to have to deal with when they go back. And, there's going to be cases now that go to discovery, and we're going to learn how many applications are pending, how long does it take, how many have been decided that were filed after me, right? And it's a really powerful thing that's just kind of mentioned in here in passing, that you could look over really quick, but will change the face of all kind of delay litigation in the Sixth Circuit and hopefully beyond. And I will tell you this, the statute that we brought this under, called the Administrative Procedure Act, as a general proposition, you don't get discovery in cases under that. But now you do in these delay cases. And, I'm telling you, it's a huge boost of leverage for the plaintiff's bar in these cases, that you can hold that over them. And then the only other thing I'll talk about, kind of from the decision, that we can talk about, what it looks like after this, is the first paragraph of this kind of second part of the decision talks about the plaintiffs and talks about their allegations of harm, that they're in limbo, that they don't have work authorization, meaning they can't work, meaning they can't get social security numbers, meaning they can't get driver's licenses, meaning they can't travel, and doesn't that part of the opinion is just very straightforward, because you don't need to exaggerate or dress up those facts. Those harm to you status applicants who are just sitting there and waiting is obvious. And the court said that those facts, in and of themselves, those allegations of harm that pretty much all you visa applicants share, if they've been waiting 2 or 3 years, that in of itself is enough to state a claim for an unreasonable delay. You don't need anything else. Which means stating a claim for unreasonable delay, especially for youth status applicants in these states, is now incredibly, as it should be, a very low bar to entry.
Well, and I mean, in fairness, if we had plaintiffs who also had DACA or TPS or something like that, they've got a social security number, they can get health care, they can work, they can do all these other things. These plaintiffs don't. These plaintiffs, I mean, and I'm sure you've spelled these out in your complaints as well. As I was writing these different factors out and sort of thinking through all the different harms that they experience in the complaints in our cases, I was just trying to put myself in the position of any typical immigrant in the U visa case where, yeah, I mean, they're not working legally because they can't. They can't do all these things. And is there any greater hardship than that? I mean, it's pretty hardship. Like, and it was reflected in the questions that one of the judges on the panel made during oral arguments. Is he said, "Well, what are the status of these people now?" And the government was like, "We don't know," and we were like, "We know." He's like, "Well, can they work legally?" And the government was like, "We don't know."
Well, and that's
You're like, no, they can't work legally. They're essentially stuck.
I think it's Judge Seiler was the male judge on the panel, and the only questions he asked were about the actual people, and he wanted to know, where are they, what are they doing, and again, I think we ended argument with this statement. It's like, look, we can go through 20 pages of jurisdiction and another 8-10 pages of these kind of logical legal arguments, but at heart, the reason we're here is these people, and they have been victims of crime. They've been courageous and gone forward to assist the police, and this is the thanks they get. And they're. I mean, don't get me wrong. I know a lot of folks waiting for U status that have good lives, make good money, doing okay, but they can't fully join society that they're trying to help and want to join because of these waits. And so I was very. Go ahead. I'm sorry.
Yeah, they've always got that specter that it could come all crashing down, and for some people it does, and they get removed.
Yeah. And so that's why I was really happy to see that the court gave enough weight to just the harm to the plaintiffs to say, look, that's enough. Look at how much these people are suffering. Government, this is getting ridiculous. And so I do think, so there's two appellate court decisions on this issue. This one and one out of the Fourth Circuit called Gonzalez. And that's it right now. I know that one is going to be going up in the First Circuit. I think that I'm not sure if they filed a notice of appeal yet, but they're going to. And it'll be interesting to see how that one goes. But for now, we're kind of 2-0 at the appellate court level, which is good. And these aren't courts that are easy to write off. You can't say, oh, it's the Ninth Circuit. Those crazy liberals on the West Coast, right? This is the Fourth Circuit's like the Southeast, the farthest thing from liberal West Coast, right? And so I'm hopeful that this will have a significant impact around the country, even though it's technically limited to the Sixth Circuit.
Yeah, a couple other notable things from the decision. We were talking about sort of the cheeky language that they use in what page is this? This is page 28. They list all those different harms that the plaintiff suffered that we listed out in our complaint. And this is the sentence: no doubt each plaintiff has pleaded sufficient facts to show that their interests are weighty, implicate health and welfare, and are harmed by the principal petitioner's years-long wait to be placed on the U waiting list. It's like, no doubt. It's not like, oh, there's a fair argument and we understand why the lower court went the other way. It says no doubt.
That's a very good point. I mean, it's just not even a question to them. And the government comes in and says, this isn't enough.
Yeah, based on these factual allegations alone, we hold. So this is official holding now. All plaintiffs have sufficiently alleged unreasonable delay deciding whether to place them on the wait list. So, I mean, if you're a typical U petitioner and you're waiting for that wait list decision and you're suffering any of these things, I mean, your case is incredibly strong.
And going back to that idea of leverage and settlement, again, what that basically means is if you're a U status person, you've waited 2 years or something, and you don't have work authorization, you don't have a social, then you can state a claim and force the government to answer and go through discovery in a case. And that just totally changes the calculations and risk of exposure to a defense attorney. And so, one of my overarching kind of nerdy projects for not just U status folks, but all delay litigation when it comes to immigration benefits is to take the motion to dismiss away from the government. And this is one big step towards that. And that's I think that will have a big impact, not just on U status applicants, but adjustment of status delays, right? I-130 delays, work authorization delays, right? In the Sixth Circuit. So I'm pretty excited about that. So
now, I had cut you off earlier. I think you were heading towards talking about MASHP.
oh,
This is the decision where the appeals court, finally agrees and understands the whole context of MASHP. And I know this is something you've personally been pushing in all your cases, because it always comes up. The government always says, wait a minute, there's this case MASHP, and it says very clearly right there, we can't just move people out of line and move other people to their spot in line. That's line jumping. That's no good.
that's right.
Here they spell it out really nicely.
They do. And James, you know, this is one of my little pet peeves when they cite this case. In an argument, I think I spent like 5 minutes on it, going over it. But the quick and dirty version is that MASHP, it was basically an application that required 3 different types of PhDs to review. They had to do site visits, interviews, like every process genuinely took up the entire office.
Yeah.
That it went in front of. Every resource had to be dedicated to an individual application.
And here the court clearly says, DHS may indeed be resource and personnel depleted, but USCIS does not deploy a team of academics to apply a sophisticated regulatory criteria to U visa applications, nor does the adjudication of a single application take years.
That's right. So it's very, again, I keep describing this decision as very satisfying, because a court finally heard that and said, you know what, that is a little crazy. And I kid you not, that case gets
a lot of play by the government in all of their motions, and every single time you just want to lash out and say, hey, wait, no, we already explained this to you. They're just trying to confuse and.
No, I think this is good. Going past this, what do I see kind of on the horizon for U status kind of litigation? We're going to have to keep going after the waiting list delays around the country. They're not going to fix things overnight because of this decision. Unfortunately, I wish they would. That'd be great. But the new BFD policy is a big step in the right direction, right?
Yeah.
But a couple of things I see that doesn't solve is, the first one that jumps out to me is this idea of members of the waiting list who are abroad, right? You can be a member of the waiting list abroad for years before you get your visa, before you come in, that under the current process, right? But the regulations require parole for those folks. The moment you put on the waiting list, you are required to be given either deferred action or parole. And we're starting to bring those parole cases. Actually, I think I just settled one today. I filed the complaint where they awarded deferred action to someone who lived abroad, and we challenged that as arbitrary. Because what does someone in Egypt do with deferred action from being deported from the United States?
Nothing.
It makes no sense, right?
It only makes sense if you can get inside the borders of the United States.
You got it.
So if somebody is granted deferred action and they enter unlawfully, will they maintain that deferred action status?
That is a great. Well, I can tell you, in one of my cases, unfortunately, the beneficiary just couldn't wait. We were so close, and he tried, and did not keep him in the U.S. But I will say, right now, if you look at their instructions and everything, there's nothing you can do for members of the waiting list abroad. And so the next project on this litigation, besides the delays, is pushing that and forcing them to do it. And what's interesting is they just won't engage. When you push that issue, they just resolve it. And what are we submitting for that parole application? Are we doing a full humanitarian parole application? No. We submit identity documents, and we submit a copy of the waiting list determination, and that's it. And they get approved, and the folks show up. And so that's years before the visa, right? The actual visa is issued. And then, the only problem with the bona fide determination system is that they say, well, we'll give you bona fide and work authorization, but we're not going to put you on the wait list. So if you're a principal and you have a derivative abroad and you get that quick work authorization, you lose that the beneficiary who lives abroad misses out and loses out on the waiting list, which would then give them parole. So I do foresee at some point applications seeking waiting list determinations for people who've reached the BFD so they can get parole, right? And so I think that's kind of an interesting thing. The other thing I think we'll see in the future is more denials that are being challenged. Because, and I think this is a normal kind of give and take of litigation, is when you see a whole bunch of applications coming in and decided quickly, you see trends in the denials, and you see new creative theories in denials. Yeah. And those are all legal denials, right? And so you can challenge legal denials. And I've already talked to some people about a couple of those. And so, but I think, to be frank, I think that's where you want to be in kind of the litigation spectrum, because then you're fine-tuning policy issues. You're not just trying to get them to make a decision. So what do you think, James? Where do you think this is all going?
I think we need to make T-shirts with snails racing each other and some sort of icon to measure the average speed of one of the snails in the race. I'm going to do that. I'm going to make one and I'm going to send you one.
Okay.
We do a T-shirt with posters.
Well, either way, I love the idea of a snails race. Maybe we can hold an annual snails race.
There we go. You know what? Ayla should do that at the annual convention. Or we could even make like you know what? I'll have I'll have my devs, software developers put together a little snail racing game, an app or something.
As long as one of them's called USCIS and it always loses.
And it always loses because it always. Wait, no, you would win if you go the slowest, right?
Well, I don't know. That's a good question. That's a good question.
Oh, that's good. My favorite, of course, near the conclusion here, my favorite part is something that I really think the lower court should have taken a closer look at. And it's just like when you're dealing with a logical problem, right? If you bring it out to its extreme, you can gauge its reasonableness, right? And so what they say is we sympathize with the burdens that the agencies shoulder. I think that might be tongue-in-cheek too, because they're a government agency. It doesn't have a soul. It does not need your sympathy, right? It says, but we cannot supplant the law with the government's policy argument that agencies should be the sole arbiters of what constitutes an unreasonable delay, because agencies are best positioned to manage their resources, and courts are ill-equipped to address resource allocation, even when plaintiffs have adequately alleged that a delay is unreasonable. So that's the government's argument, right? They're saying they don't want to take that. They say, taken to its logical conclusion, the government's argument would eliminate federal judicial review of any agency action and wipe the APA off the books. Exactly the point in the whole jurisdictional argument, right? The APA exists, and it exists for a reason. And to follow the government's radical argument, as the court says, would lead you to that conclusion. So in summary, I know we sort of, we probably could have said this part at the beginning. Let's just go through the conclusion. We conclude by restating our holdings. Oh, the other thing I liked about this decision, it goes through a very complex section, right? And there's parts where, I don't know if I said this to you already or if I'm just repeating what I was telling my wife at lunch, but this is the law. Why does it say that? Because this and this and this. So you usually don't see that in a judicial decision, right? Oh, the self-reflexive why question, which cues itself to explain further. However, as my wife was pointing out at lunch, that's actually very helpful for us, the plaintiffs bar, because it spells it right out for the lower court, when they're looking at it again. So not only do they get the conclusion, but they get a very detailed reasoning of why.
And again, it also takes the government to task, because part of their defense of our case was, plaintiffs' arguments make no sense. They're inconsistent, and they don't understand the law. And what the court said in response was something to the effect of, the government is misstating the plaintiff's logically coherent arguments. And that's why I think they just the government overreached in this case.
Here's the quote. Here's the quote. And we talked about this yesterday. The government mistakenly blurs the line between 701A1 and 701A2 and misleadingly obscures plaintiffs' logically coherent contentions. Now, it's no secret. I give Brad all the credit on these cases. He's the one who coached me to start taking these cases. He gave generously of his time to sort of walk me through the process of starting this litigation in the federal district court here, and really took the lead when it came to filing the appeals. He did all the heavy lifting on oral arguments and on drafting all the brief writing. That was Mr. Attorney Brad Banias' work. So when the court says this about the plaintiff's logically coherent contentions, what they're really saying is plaintiff's counsel, Brad Banias's logically coherent contentions. As I pointed out to Brad yesterday, if you're ever in a discussion with a family member, a loved one, could be your wife, could be somebody else, and they're like, you don't make any sense, you're being illogical, you can cite circuit court case law that says quite the opposite, that you have logically coherent contentions. It's a useful citation to keep handy.
Well, I've never been accused of being logically coherent, but it's and thank you for your nice words, James. But it's nice to see the court push back a little bit. And I will say this, while we work together on this, James, I think you are downplaying your role too much because there's not that many attorneys that use litigation as an actual tool, effective tool in their petition-based practice. And James, you've done a great job of identifying this to help a large section of your client base and gone after it with vigor. And, while you want to win at the trial court, and I know you have, because they stop right there, right? Mm-hmm. It's for your clients. They should know you're willing to go all the way, right? And push it and get something that benefits them. But this case is called. Oh, thank you. It's called Barrios Garcia. It's not called James. It's not called Brad. It's for Edmer, right? And his case definitely benefited him, but he, by being the plaintiff and going forward with this, and James having the foresight to encourage him to, he is now responsible, and the other plaintiffs for helping hundreds, thousands of people across those states. And so I don't want to look past that, because it takes courageous plaintiffs, courageous immigration attorneys to say, hey, I think there might be a better option for you. Mm-hmm. And then we all get together and do it. And so those are the real stars of this. And again, I go back to it. You wouldn't see a cheeky, satisfying decision unless these judges felt for the plaintiffs. And it's clear that they did. So much so that you said, you're right. It's just no, boom. There's no doubt this is enough harm.
There's no doubt. They're logically coherent. They're misleadingly obscuring. All wonderful things to hear when it's in our favor. And I can tell you that even in the same district court where we lost originally, these first three cases, I know of another attorney who we've been helping, and we've been working together on a case there, and she got the opposite decision at the district court level. She survived her motion to dismiss for her clients. And in that decision it was a different judge, same court, different judge. She cited the existence of this case, for these cases pending in the Sixth Circuit. And I don't think it's unreasonable to believe that they may, I don't know, is this possible? Can they call the Sixth Circuit judges and be like, hey, where are you guys going to land on this? Because we got this thing we got to rule on. Does that
happen? Having worked for both a trial judge and an appellate court judge, I don't think I ever saw it.
Oh, okay.
But they are all buddies. They all know each other.
Well, they landed on the same place. So for her case, it was great because she doesn't have to appeal it now. She survived the motion to dismiss. And so they're going to enter into discovery and whatever steps come next. And so it's our hope, now that it's spelled out very clearly, that we can go to the rest of our plaintiffs who were a little hesitant because, I mean, federal cases are not cheap to start, especially when the outcome is a little more uncertain. Well, now they're a lot more certain. And now we're a little more confident in being able to tell them, you know what, it's time. Let's put you all in a giant case together. Let's, make sure your claims are similar enough. But yeah, there's going to be many, many dozens or hundreds more who can benefit, at least even in just this district.
Yeah, well, I can tell you, I brought one in North Carolina alongside of a nonprofit who represented battered women. We had 81 plaintiffs, and we won the motion to dismiss, and they issued waiting list decisions to 81 people, and we got, I think, 25 paroled into the United States.
Wow.
And so, once you have this, you gotta keep pushing. You gotta keep pushing, and at some point, I don't want to push these cases. At some point, I want the agency to go, okay, we've got to fix this, and I hope they will. That's the overarching project of all.
Yeah. And with the
to fix it.
With the very straightforward language that they use in the decision, they go through the section which explains some, complex things. Maybe they say, to sum up, this and this and this, and all I can think of when I read that phrase, to sum up, because they do it multiple times throughout the decision. That's helpful. But I think of The Princess Bride. There's a part in The Princess Bride where his name Diego Montoya.
Oh yeah,
my name is Diego Montoya. He's like, well, where the man in black wakes up, right? He wakes up from being mostly dead for part of the day. And he's like, what? Where am I? Who are you? What's happening? He goes, I'll explain to you. No, it take too long. I sum up for you. So he just says he's going to sum up what's happening there. But yeah, they say to sum up, to sum up, to sum up. Lost your video there, but I can still hear you. And then, so at the very end of the decision, the government talks in their conclusion and they say, the BFD process moots no part of the case. 5 U.S.C., the other jurisdictional sections, they don't bar the federal courts from reviewing these claims of unreasonable delay. The federal courts may compel USCIS to place petitioners on a wait list when an unreasonable delay has occurred. The federal courts, 706.1 allows the federal courts to command USCIS to hasten an unduly delayed bona fide determination, which is a mandatory decision, and the BFD process. We hold, however, that the federal courts can't invoke 706.1 to force USCIS to speed up pre-waitlist work authorization adjudication, which is a non-mandatory agency action. And when I read that, I was like, whoa, wait, but that's okay, because as long as we get the bona fide and pending determination, that's the next logical conclusion, right? So it's we can't force them to issue the work authorization because that part's discretionary, but they can be forced to do the bona fide and pending determination. And they say we've pled sufficient facts that USCIS has unreasonably delayed. And especially for this case, right? We're allowed to amend our complaint to include allegations about the BFD process. So.
And I'm hopeful we see quick resolutions for these plaintiffs. We've gotten their cases reversed, and in the Fourth Circuit, we got that case reversed. We saw waitlist determinations issued pretty quickly. And so that's where I'm hopeful, because the agency doesn't really know what to do after they lose motions to dismiss. And that's what they just lost here. So I'm hopeful we don't have to go into discovery, at least for these folks. Maybe the next ones. They've been through enough, waiting long enough. Let's, put this one to bed and let them get on with living life in a more safe and secure and reasonable way.
Yeah. So good news all around. I was really happy with the decision, and it reminded me, I left my hat in the car. I was wearing it all day, my Cincinnati Reds hat.
Nice.
Celebration.
Yes.
That cements my fanhood of the Cincinnati Reds.
Good. Yeah, they're our good luck charm. Well, thank you for letting me join you, James, to tell your folks about this, and thank you for joining the case and helping and getting it all done. I think it's a good decision that will be tough to rival in other courts, and so I look forward to trying. Keep pushing forward.
Well, thanks again for your time. Generous as always. I appreciate it. Thanks, Brad.
Good to see y'all. Thank you so much.
Bye-bye. Don't leave yet. Don't leave.
Okay.
All right, thanks for listening. And as always, this show is brought to you by Prima.Law. Now, Prima.Law is online legal case management. We have case management, contact management. You can add your notes, tasks, phone calls, things like that. And we've exploded with a number of new features this year. For example, we have a calendar. We have our very own calendar with Google Calendar integration. You can now also send text messages directly from Prima to your clients, so you don't have to give out your personal phone number anymore. And you get an email notification when somebody sends you something via text to your firm. So everybody in your firm is going to be able to see who's texting, and you can get those things assigned and going. And you can also send images. That's one thing that we've noticed is with a lot of text messaging applications, they'll support texting, but they don't support the images. We support images, so your clients can be texting you pictures of stuff all day long. And that's going to go right into Prima. We also have a Chrome extension which lets you collect data from government websites. So if you need to grab I-94 information or information from the EOIR website about your immigration court case, or if you need to grab an update on the USCIS receipts, you can do that all with our Chrome extension now. And the biggest thing that we've built this year is the billing features. It's billing, it's time tracking, it's invoices, it's creating payment plans and being able to account for how much of a payment plan is now earned and how much is unearned. So you've got two separate general classes of invoices. One that's dedicated just to your payment plans, because those are important. Those are things that people need to pay. And then you've got your normal invoices where you can bill against the money that's been coming in. And we built trust accounting. So you can say this money was put into the trust account and then I earned it and I put it into my business account. And so it's a great way of keeping track of those complicated cases where people have a payment plan, maybe they've fallen behind on their payment plan, and now they're going to have an invoice that's not going to be covered. You can see that immediately in Prima. And the best part of all of this is we have electronic payments. We have Prima Pay. So you can receive credit card payments, bank account payments, ACH drafts, right? E-checks, sometimes they're called, but credit card, debit card, all those electronic payments now you can automate, you can take those and record records of those transactions directly inside of Prima.Law. It's been a busy year. We've still got a lot more to do that we'll be telling you about soon, but got a lot of great plans there. If you want a free trial, go to our website, Prima.Law. Sign up for a free trial, start using it. If you use forms like immigration forms, California forms, all the Judicial Council and county forms, New York forms, or if you're a Michigan attorney and you use Michigan forms, or Social Security and you need Social Security forms, or if you practice in federal court and you want to be able to autofill those federal court forms, we have those as separate libraries you can purchase. If you don't use any forms or you're not from one of those states, we can also serve any attorney in the United States because we have all these awesome core case management features for as low as $10 a month. It's an unbelievably low price. It's very accessible, very easy to use. So Prima.Law is the website. Go sign up for a free trial. Again, thanks for listening to the show. Hope you have a great day.